Welcome to our podcast. I'm Ken Lumb, managing partner at Corboy Demetrio.
And I'm Bill Gibbs, also a partner at Corboy Demetrio. Today, we are on the road for Masters of Trial Law. And we are in San Diego, California, where we're going to spend some time with the CEO of the American Association for Justice, Linda Lipsen. Linda, welcome to the podcast.
Thank you.
Great to see you.
Great to see you too. In this beautiful, beautiful San Diego.
It is amazing. It is an amazing spot. So we're here at a conference of trial lawyers at a group called AAJ. Many people might not know what that is. Can you just tell our listener what it is?
Yeah, we're trial lawyers that represent people. We don't represent companies, and we represent people that are harmed by dangerous products or shoddy conduct or whatever. We are many thousands strong all over the country, and we're fighting the good fight to make sure that when people are harmed that they have remedies.
How many people are in the organization?
Over 20,000, but that really doesn't define the whole organization, because we have about 60,000 lawyers that are also in state organizations, and we include them in our family.
We're surrounded by seminars and other types of continuing legal education. And so, one of the things that AAJ does is to educate lawyers and keep us up to date. Tell us about the other ways that AAJ protects consumers' rights.
Well, we have a state affairs program where we provide resources to the states so that they can fight back when companies are trying to get advantage over consumers.
Companies would try to do that in this country?
Yeah, in this country, they would try to do that. And we have a magazine that we put out once a month that helps trial lawyers and represent their clients better and make sure that they're modern and they have all the technology that they need to be able to fight back. When lawyers go into court, our lawyers go into court, it's usually one or two of us compared to a sea of corporate lawyers. And so we need to have the tools to be able to fight back. And that's what AAJ is dedicated to providing.
Tell us a little bit about how AAJ protects the right to jury trial. It's ironic because this is the 250th anniversary of the Declaration of Independence. And many people may not know this, but I'm a history nerd. One of the only two rights that eventually became the Bill of Rights that was mentioned in the Declaration of Independence as a grievance as to why we had to go to war to become independent from Great Britain was the right to jury trial in civil cases. Tell us about how the corporate America and the government has been eroding those rights.
Well, the jury trial is sacrosanct. It is the only place that an individual consumer can be treated in the same way as a king or a president or as someone that has means. So it is a great leveler, and it needs to be protected no matter what. What companies are trying to do now, they're very, I don't want to overgeneralize, but pretty much in anything you buy now, whether it's a cell phone or whether you take your mom to a nursing home or whatever it is, the companies have now come up with a new strategy where when you, before you buy a house, before you buy any expensive item, but even now it's going to non-expensive items, where there's a clause in the terms that you don't even know what it says, that we call forced arbitration, which if something happens to you later down the line and you get hurt, you have just signed away your right to a jury trial. And so we're on a tear to try to get rid of that because it's just completely unfair, completely imbalanced. And we're making some progress there. Last Congress, we were able to get a bill passed that would end this practice in sexual assault, sexual harassment kinds of cases. And it has had a remarkable effect on men and women that are seeking employment, that they'll get to know if their employers have a history of sexual harassment or sexual assault, and they can go someplace else. We want to do the same thing in nursing homes and extend it to all products. And in fact, there's a bill called the FAIR Act that we are pushing, and we have been for a few years now, that would make arbitration voluntary and make the decision about whether to go into it after the dispute happens, not before. So we've done some polling all over the country. It turns out, it's not surprising, but it turns out that whether you're Republican, a Democrat, Independent, no one wants their rights taken away. And so it's very popular. But in the lobbying culture around DC and around other state legislators around the country, the companies are pushing a strategy to protect forced arbitration in every way they can. So we're on a tear. We're going to keep fighting this, and I believe we can make real progress. Because if we get a bill to the floor of the House or the Senate, it will pass. It will pass.
And that can be as simple as just downloading an app, and then once you start using the app, you've agreed.
Yeah,
to
I mean, you
arbitration.
haven't agreed. You don't. I mean, to think about it. If you think about it, you're agreeing to the company that hurt you, that you think hurt you. They get to set up the program. I mean, what could go wrong? They get to decide, and it's secret. And it's secret.
Right.
It's all secret. And
No discovery.
no discovery, no nothing. And so, like, you're more likely to get struck by lightning than to win in forced arbitration. I mean, it's ridiculous. So, and that's why the companies are trying to protect it in the ways that they are.
It's just not fair.
It's ridiculous. It's so unfair, and people don't even realize they're signing it. Myself, I'm a good consumer advocate. I have been for years. I had to take my mother to a nursing home because she was getting Alzheimer's, and I had to. They gave me about a 50-page contract, and I, as a good consumer lawyer, I ruffle through it, and I find the sentence. I find the sentence that says, something happens to my mother, I'm going to be subject to forced arbitration, my family. And so I told them I would not sign that. And so I initialed it. And I felt like very, very good about it, that I was asserting my rights and everything was great. And then I went home after, and the nursing home was close to my house, which I'd read all about it, that, your mother's going to get better care if you can see her a lot. And so I felt so great. And then I got a call from legal at the nursing home saying that my mother that we couldn't finish the contract.
If they wouldn't accept
They
it
wouldn't
without-
accept it without it. And I had to sign it. And I had to sign it. And it, look, immunity makes no one safe.
Correct.
No one is safe.
Correct.
And so you have to have accountability. And so we're gonna continue this fight. It's a righteous fight, and I think we're gonna win. It may take a few years to do it, but we're gonna start with. We started with sexual assault. We're gonna move to possibly nursing homes to try to get some fairness there, and then we're gonna hopefully make it impossible for all product manufacturers to include these clauses in general, so that people will have a right to a remedy. The Supreme Court, we're perplexed by the fact that, when I went to law school, there was something called a contract of adhesion.
Yes.
An unconscionable contract. Right. This fits the definition of what that is.
101, yeah.
Right, and I go, did they teach that anymore? I'm not sure. And then the Supreme Court decided to throw all that out and say that that's just fine. When the Arbitration Act itself was passed so many years ago, it was a business to business. They never contemplated that your grandmother would have to be subject to arbitration. It was always the rules were constructed to apply only to businesses against businesses. And the Supreme Court didn't find that, unfortunately. And so now here we are. We have to get legislation to undo that.
Yeah. You made a very good point earlier that when consumers understand what they're giving up, they get it.
Yeah.
But it can be confusing. So when we're talking about arbitration, we're literally talking about removing a fundamental right, part of what it means to be an American, and letting a corporation decide, letting arbitrators who are paid by the corporations and who can't make money unless the corporations will come back to them, decide this dispute without any right to receive documents, take depositions. It's a sham.
It's completely unfair. And then when people realize it, they're shocked. What do you mean? I can't assert my rights. I have to go in front of the people that harmed me in the first place. This is un-American, and so we're on we're going to win this thing, because we're going to win.
You will.
But it's going to take
side of it.
It's going to take everything we have to do that, and it's going to take consumers rising up and saying this isn't fair, and we're going to win. And then all this is about is making sure that people have rights and that they're safe. And we can't continue this culture of folks being unaccountable for the harms they cause. So it's very simple. It's what you learned when you were, your mom taught you that if you did something wrong, you were going to have to apologize and you were going to have to pay for it. I mean, you can't tell a major corporation to go to its room. You have to go to court and you have to ferret out the facts. We don't say we want to win it. We have to win every case, but give us a chance, give us a shot, right?
Right.
You've been fighting for people like that your whole career. Where does that come from? I mean, when you're in law school, are you thinking I want to work for?
I am.
The person that's been wronged?
Well, I started out as an antitrust lawyer, and they put me in it was before the growth of the internet and ChatGPT and all that. So I was put in a room with lots of documents.
That sounds
and
fun.
It was really fun, and I was really terrible at it. I go like, this is boring, and I don't want to do anything boring. And my dad was very active in the civil rights movement. He was a lobbyist for the labor unions. My mother worked for the Speaker of the House. We were always told at the dinner table that we were supposed to make a difference. So and it's fun because you can see progress, and you can see progress when everybody tells you that progress is impossible. You can see it.
Right. Yep.
And sometimes I'm not the most patient person, as you can imagine, but you can see it. You can see that you're making a difference, and that's just the most fantastic thing ever.
You've been doing it.
I've been doing it a long time,
and you've been doing it very well.
Well,
so we're all
thank you.
We're all appreciative.
Thank you. I'm lucky to have. I feel fortunate. I also feel like right now, in this culture of unaccountability, I feel like the lawyers are so important because, the agencies, you walk through the agencies that are just supposed to protect consumers, and there's nobody there. You could hear an echo, in the halls of these agencies, and the lawyers are the ones bringing the cases, bringing the opioid manufacturers to account, bringing the rideshare companies to account. When their drivers sexually assault folks, the lawyers are doing this. So I feel really fortunate to be able to do this and to help protect what the lawyers do because it's just so important. Everybody has families; you got to protect them, right?
Absolutely,
100% correct.
You mentioned immunity in federal agencies. Tell us a little bit about that line of attack from corporations, immunities and preemption.
It just happened this week, where the president said that pesticide manufacturers should not be held to account for harming individuals because the product that is in Roundup. A pesticide, that product is linked to national security. I mean, that strains who thinks that? Wow. Let's protect people.
Exactly. It's ironic because just recently a scientific article that has been used by the manufacturer of Roundup for decades to support its safety has been retracted because of scientific misconduct. Monsanto basically ghostwriting it and handing it.
Exactly. And look, farmers need to be protected. They need to know, they need to read the label and say, oh my gosh, I have to wear some protective clothing here.
Right.
Because this could cause cancer.
Right.
But why are we keeping that a secret? I mean, people are not stupid. Inform them. Let them, treat them as adults. But the company won't do it, and here we are. So, yeah.
And when you're talking about immunity, you're talking about this legal concept of federal law preempting state law, so that companies can't be held accountable under state tort laws, laws of negligence, and it's a very complicated area, but at its heart, it really is, it's something that's supposed to be used sparingly. There has to be specific congressional authorization for that, because it is an erosion of states' rights.
Right.
Which is what these people supposedly are for.
Yeah.
They're all about states' rights.
Well, it's pick and choose.
Exactly.
Well,
That's
one thing that
states' rights and choose.
States' rights is in the Constitution. It's the 10th Amendment. But what has happened over the last few years is that it's kind of like, I don't know, when my grandmother was getting married, I helped her with her prenup. And she said, here's the prenup. What's mine is mine, and what's his is also mine. Okay? And so this is the same thing with preemption. Do you know what I mean?
Yes.
Because it's all about outcome. And so the companies talk about states' rights, except when it pertains to them. So, I understand this because I had to write that prenup. Yeah, they want it both ways. It's all about outcome. And they want to win everything. And I go, you know how you win everything? Make it safe.
Absolutely. Pretty simple.
Make it safe. You don't have to go to court. People don't have to get injured. This isn't hard. How about not being a crybaby and going to Congress and state legislatures and saying, oh, people are hurting me because I have to be held accountable for the harms that I cause. I mean, really?
People want safe products, and lawyers are there to ensure that these companies are putting out safe products.
Right.
I mean, you've been doing that for
Yes.
almost your whole career.
Yes. Well, I did. I actually did it before I came to this job, because I was the legislative director for Consumers Union, the publisher of Consumer Reports.
Yep.
So we were very active in the space then. You have a right not to have a product blow up in your face. You have a right to go to court and say, this product blew up in my face, and you lawyers help individuals rebuild their families after hardship and loss. So, it's, again, sometimes we get too into the legalisms and talk about concepts that we learned in law school that nobody understands, and we bore people into the ground. But this is just about safety and accountability, and when you really get to talking to real people that are not in Washington speak, they agree with us.
Right. Yeah, it makes
right?
sense to our common sense. Right?
Yeah, it makes sense to theirs too.
Yeah.
So, the companies, whether they're internet platforms or whether they're manufacturers of toxic chemicals, or whether they're in the medical industry, if they put their focus on making it safe, they would be saving so much money. Exactly. And providing real care to the public. Exactly. So that's really what we're about. We want to make sure.
If they would just apply some of the money they spend lobbying state governments and the federal government for immunity, or for damage caps or other things into the safety of their products, we wouldn't have this issue, right?
Well, yeah, and then lawyers, we have to be proud of what lawyers do, because, like, if you look at a car, The roofs that don't collapse upon impact, that was because of lawyers. Brakes that work, that's because of lawyers. Seat belts, airbags. I mean, you name it. You could just go through every ingredient of a car, every safety implement that was added to a car because of what lawyers do.
Right.
We shall be proud of that.
Right.
That's a good point.
Yeah.
Lawyers sometimes get a bad name, but there's been a lot of good advancements
Of course.
in safety because of lawyers.
I'd say everyone.
Yeah.
Everyone, unless the company realizes, boy, I can use this. I can market my product by my safety record.
Right.
Like Volvo, you were saying. Volvo.
Yes,
has done
it's
a great job of that.
fantastic.
Yeah.
It's fantastic.
Embrace
Shout it from the rooftops.
that you are the safe product.
Look, people are very safety conscious. When I was growing up, nobody wore bike helmets.
Right,
everybody
yeah,
said,
right.
Like, you're not wearing a bike helmet?
Yeah.
You feel bad.
Right. Seatbelts.
I want my hair to fly in the wind. No, you got to wear a bike helmet. You got to have seat belts. And you got to not smoke. All those things. Many of those things were caused because what lawyers did. Right. That's something to be proud of.
So I played football, coached football, and then represented former NFL players.
Oh.
And I truly believe that the work that was done by lawyers in that case have made the game safer. It's not safe.
Totally safe. Yeah.
It's just not a safe game, but it's made it safer.
I feel bad. I have to confess, I feel bad about this because I let my son play football in high school, and he actually ruptured his spleen on the field, and I just thought, why did I allow this? How did I let this happen? So I'm a bad mother, but
Well,
I'm sure I'll go to therapy.
I let my boys play too, so there's pros and cons.
I mean, it's a great game.
When you go in eyes wide open and you know the risks,
it's a great game, but it has some real risks.
Yep.
I mean, we're never going to be totally risk-free, of course.
Exactly.
But there's so many things that we could do to make things safer. And we always have to be on the hunt.
Absolutely.
Like, what can I do to fix it? That's one of the reasons why I do this work. Because I think there's always something to fix. There's always something out there like you can make better.
Right. And the market can't do that because the market is always going to choose what's cheaper, and it's always cheaper.
Except
if
that they can advertise the safety of their products, and I know this from working at Consumer Reports. Like when you rate products and rate them on their safety, it is a compelling reason to buy the product. And if you have a terrible safety record, that's not good.
Yeah.
And the medical industry has been doing whatever they can to deny consumers, patients, the right to know
that information.
Information.
Yeah.
I go, information is power.
Yeah.
Let's get it all out there and let the marketplace work.
Yeah. Tell us about damage caps. Another way that organized money tries to take away the right to jury trial.
I think damage caps are, very, very harmful, but ridiculous too, because you don't have a cap on suffering, and so each individual is different, and so how can somebody that loses a child or has a child that had, let's say, an injury, a medical injury from medical malpractice. Let's say that child lives for 18 years with like horrible ramifications from something that happened in pregnancy or in birth. But that should not be subject to a $250,000 cap. Right. And when you unpack that for individuals and explain that, no one agrees with that.
Right, it makes no sense.
No one makes it. Right. Yeah. And so what's happened now is that some of the states have actually, there was this flurry of work on that companies and the medical industry did in the 90s, 80s and 90s to cap damages. And so what's happening now in many states, they're elevating those caps. But I mean, the cap was never adjusted when it was first done in California. Actually, it first started here. When it it was never adjusted for inflation or anything.
Just
so
arbitrary
$250,000
number.
arbitrary. So $250,000 cap in I think it passed in 1975 or 1976. I mean, what is that worth now? So plus another fun fact is that in the states that capped damages, there was this effort to say by the medical industry that capping damages would bring insurance rates down. And guess what? It never did. And so we say, okay, if you're going to do this, you have to return the money that you're going to save because you're not paying people that you've hurt. You have to return that to consumers.
Right.
And so that never happens.
Exactly.
And then people move on. So, damage caps are terrible, and they're actually out of favor now. They're moving into other things, which are just as pernicious, but maybe more creative. Like right now, there's this move to make it impossible for lawyers to get the capital they need to pursue their cases. You've got to hire an expert. You've got to, in putting together a case, there are a lot of costs. And so what a lot of tort reformers are trying to do is make it impossible for you to get the capital that you need to do your cases. So they're doing the same thing as caps, only they have
just from a different angle.
More creative strategies.
Yeah.
And so I think our opponents are very good at complexifying everything, making everything just impossible to understand. And then you realize that, oh my gosh, that all this means is that the companies are going to be unaccountable for the harms they cause, and the public is going to suffer. We can't have that.
Right.
So anyway, this fight will never end.
Let's break that last point down a little bit, because when you're talking about lawyers getting the capital, having the resources they need, because what we do is virtually all, if not all, contingent fee contracts. And corporate America loves to disparage that, but a contingent fee basically just means that we don't get attorney's fees unless there's a recovery for the client,
right.
And we front all the expenses.
Right.
And if there isn't a recovery, if we try the case and lose, we eat the expenses.
Right.
And the point of that is so that ordinary people can afford good lawyers, who can go toe to toe with the corporate interests, and big organized money hates that. And that's a very good point, because that's just another point of attack to come at that people don't understand, consumers don't understand when there might be debates about that. But it's important to be informed in the fight.
Well, another strategy is something called loser pays.
Yes.
Which is a relative of what you're talking about, and that's terrible because just think about it. I'm driving a GM car, and the exhaust blows up and causes severe injury to myself and my children in the car, and what if I lose the case? And it's a very complicated set of facts, very complicated from a standpoint of what kind of experts you have to bring in,
which component,
it's complicated, expensive. I'd have to pay GM's lawyer fees when they're on an hourly basis, and like the baby lawyer in that's representing GM is getting $600 an hour, and the main partner is getting whatever. It's off the charts.
Right.
I'm going to do that. So in other words, if I file a case to assert my rights, I might lose my house.
Yeah.
I might lose my retirement.
Exactly.
I can't do that. So it's what the strategy is to make the case go away.
Right. Exactly.
That's always the root. Let's make this case go away. And so unfairly,
right.
the consumer doesn't get justice. And they're stuck. And the thing that nobody understands that really gets me really mad is that the consumer ends up subsidizing the wrongdoer. That is just terrible.
Right.
So we can't have.
Sense.
Yeah, you can't have the consumer that gets harmed by a defective exhaust system who can't file a case because they've made it so impossible to recover because of tort reform. They end up they're basically subsidizing the wrongdoer, and worse, that particular product that caused the injury is going to cause it for other people, and they're subject to some kind of secrecy order, and they can't tell anybody.
Right.
So we can't protect people.
That's not accountability.
So instead of protecting people, they're spending money on lobbyists and PR firms, et cetera, to make it impossible. So again, there's always something to fix.
Yeah, absolutely.
Yeah.
And the system that we've had that goes back to the founding of our country, if you want to talk about originalism, right, has always been both sides pay their own expenses, both sides pay their own way.
Yeah.
And the whole point was so that ordinary citizens could fight the government and could fight corporations.
Yeah.
And these are all just ways that they try to erode it and chip away at it, right?
That's right. That's right.
What other things are happening now that consumers should be aware of?
Well, okay, so anybody that knows a kid, has a kid, seen a kid, we all know that they're addicted to screens.
Yeah.
We do. Everybody does. You don't have to be a Democrat to know that. You don't have to be an independent.
And some adults, too.
And some adults. Okay. So what does that mean? That means that the public is addicted to screens, and sometimes the algorithm is encouraging them to be suicidal, to have eating disorders, to be trafficked, all kinds of things. We all know this. And so in the 90s, the internet platforms, the fledgling internet platforms came in and said, we got this cool technology. It's like really cool. And Democrats and Republicans said, yeah, this is really cool. Let's give them complete liability protection, complete immunity. And they wrote something called Section 230, which prevents any consumer from saying, wait a minute, my child is becoming anorexic because they have repeated images that are being sent from the algorithm that is encouraging them to look a certain way. I want this to stop. I want this never to happen to another family. And then there's the companies come in and say, well, no, in the 90s we got this thing, which we think is really cool, and we're going to keep holding on to it. Well, we don't agree. And the lawyers don't agree. A lot of the lawyers don't agree. And so they are, instead of looking at it as a content-related issue, they're looking at it as this is just a design error. This is a defective product.
It's a product.
Right. This is a product. And so right now, we're working with a lot of parents throughout the country that see their children fading because of screen addiction, and we're asking Congress to do something about that, and we're getting some traction there. So I have a lot of hope where that's concerned. But again, we have the biggest companies in the world that are fighting us, the biggest companies that just helped purchase a ballroom in the East Wing. So it is a huge lift. But, at some point the public, what the public believes is going to matter. And so I'm actually very optimistic that we can get some success here.
That's really
Start with kids. It's not just kids. I watched my grandparents also addicted, we're addicted,
Right.
and so, but start with kids because everybody knows this is a huge problem.
That's really important work.
Yeah.
Really important work.
Yeah.
And you got a lot of important work to do, so we're gonna let you get to it.
Thank you.
It's been amazing spending some time with you. I mean, I've admired you for years and
Thank
years
you.
and years, and what you do for the people of this country.
Thank you. That's so nice.
Truly is.
Well,
really
I want to say that I have a lot of help. I have a fantastic staff. People ask me like, well, what would they do if they didn't work for AAJ? And I say, well, I don't know. Let's think. I don't know, maybe SEALs. I don't know. And they're fantastic and really committed, and they make it all work. And then the lawyers, we get a lot of we have to get technical help from the lawyers when there's an issue on the floor of the House of Representatives or the Senate. We are informed by the lawyers to make sure that we're getting it right. So it's it takes a village, but it really does. So thank you for having me, and keep doing that good work.
Thank you.
Thanks for being
Great
here.
to be with you.
Thanks.
Welcome back to the Corboy Demetrio video podcast, Masters of Trial Law.
We're joined here by a famous trial lawyer from Hawaii, Wayne Parsons. Wayne was actually the founder of the Hawaii Association for Justice, and has been heavily involved in AAJ for decades, particularly in trial lawyers' care and in public education. Wayne, welcome, and thanks so much for being here.
Good to be here.
Thanks for joining us.
Tell us about trial lawyers' care. What is that?
Well, Trial Lawyers Care actually was created at the time the Twin Towers went down in New York City. And Leo Boyle, who was then the president of AAJ, called the executive committee together and said, what's happening? Lobbyists for all the airline industry, every corporation, insurance company, they're descending on Washington, D.C., trying to get immunity bills passed so they don't have to pay for anything. They're not responsible for anything. And nobody's speaking for the victims. There's no voice in there saying, well, what about the people who were killed? What's going to happen to their lives and their families? And in a very short period of time, a team from Washington, from AAJ, from ATLA, went down to Washington, to New York City, and went in and said, we want to speak for the victims. We want to try and do something for the people who were killed. And they created a program nationally where members of this organization, AAJ, would represent the families of the victims without a fee.
Pro bono.
Pro bono. And try to get them justice. They participated with, there was a victims compensation fund that was set up, and they participated with the creation of that system and the rules in that system so that the victims actually would be compensated. There were no lawyers' fees deducted for the work that those lawyers did. Lawyers from all over the country, trial lawyers from all over the country, members of AAJ, flew to Washington, D.C., worked on this, and worked in New York City to get justice for those victims and provide funds for people who had lost a wage earner in their family, or whatever consequences resulted from the tragedy. And that program went on for 2 or 3 years. Some lawyers, I know there was a lawyer named Bill Malk from Montana who moved to I don't know, either New York City or Washington, D.C., and he was there for like a year doing it. It was a major, major effort, and it was given the name Trial Lawyers Care. And of course, those of us who do this for a living, we understand that's actually true. We like people, we represent people, we stand between people and the abuse of power and justice, and we try to provide justice to people who can't really afford to hire a lawyer that work on contingency fees. So it was a great program. And when it was over, it was sort of a one-time thing. It went on for a few years as the monies were transferred and everybody was taken care of. But about 10 years later, 10 or 12 years later, Mary Alice McClarty was the president of American Association for Justice, and she said, Trial Lawyers Care that's what we are. It was about this one incident, but that's what all these law firms around the country who practice plaintiff's personal injury work are doing. So why don't we resurrect it? Because it's still going on. She'd been in New Orleans after the hurricane, after Katrina, and she was there with her blue jeans on and her sweatshirt handing out supplies and working in the community. And she looks over to another table. There's Fred Barron, who was the president of AAJ at the time, and his wife, Lisa Blue, and they're doing the same. And Mary Alice said, I came home and I thought, this is who we are. This is what we do. We show up when there's trouble in the community and we help people. And she said, let's resurrect the committee. And it got resurrected, and here it is today. And what Trial Lawyers Care is today is trying to highlight all of the good things that lawyers do and encourage lawyers to do more and to get involved in more. And so if there's a disaster, a hurricane, a fire, Trial Lawyers Care will implement, the action part of it, which is let's go in and see how we can help the people and have some experience in things as complex as a victims compensation fund and getting lawyers to work pro bono in certain situations. So that's what Trial Lawyers Care is. It's alive and well. It's going on. We hope there are no disasters this year, but there will be. And there will be things where it's not a disaster, but there's a big need in a community somewhere, and Trial Lawyers Care will show up. At AAJ, we try to collect those stories. We try to get them out and let people know if there's a problem, this is a place you can come and talk to somebody about what you could do about it.
Tell us a little bit more about public education arm of AAJ and what we're doing.
Well, AAJ, of course, that's the main organization that actually lobbies in Congress and that goes into the community to protect the justice system. And the Public Education Committee at AAJ doesn't have the kind of funding that the insurance industry has and other corporate interests have, so cannot run television commercials. But the hope is that through our clients, we could spread the word about what we do, and through programs like the People's Law School and other, going into the schools and presenting the typical work that we do and how we charge, we'll defer some of that criticism and some of that the attacks on lawyers. And so what we're trying to do is get the word out and trying to get lawyers doing things like what you folks are doing. You're putting these on YouTube,
right?
To really let people know what the legal profession is about and get the true facts out there. It's a pretty simple concept, and I think with new technology, it's going to be much more successful than it's been in the past.
In addition to lawyers like yourself telling the story, of the good work that trial lawyers do you utilize the clients, the actual injured people that have gone through the process of pursuing a lawsuit with a lawyer and hopefully obtaining some justice? Do you utilize those people to tell the stories?
Yes, they're the best storytellers.
I would imagine so.
I just remind my clients that I'm their employee. I work for them.
Yep.
They're the boss. I'm the worker. And what they have to say, their experience is important during their case and after their case when they can actually talk about it. So yes, we'd like client stories. We'd like them to tell their stories. My clients, and I'm sure you're the same, are heroic people who have been knocked down and are coming back, and we just help them get back on their feet. And their stories are magnificent, and they go through things with great composure and great understanding of the fact that they've had a loss, and we're trying to help them, and they're trying to get back on their feet. So it's a great opportunity to tell the public about the justice system and how it works, and about the plaintiff's lawyers is to let the clients talk. Take Justice Back is another program at AAJ that collects those stories. And that website, Take Justice Back site, anybody from the community can go and say, I've got a story to tell.
It's great.
Right.
That's
They
great.
need to get their lawyer's permission to do that. Although if they have an active case, I would suggest they check with their lawyer before they talk during the case. But it's a good program. It is difficult. Believe it or not, it's hard to get lawyers to go to get their clients and get them up on the screen, even though it will make the lawyer look really good, and the clients will be happy to tell their stories. We need more lawyers to do that. So if anybody sees this video and they're a lawyer out there, I would think get a hold of some of your clients with the good stories and go to Take Justice Back. You'll get assistance in getting that story out, and it might even be nationally available.
And it's so, because when you talk about lobbying on this side, it really is about educating legislators and regulators. And the best way to do that is to show what are the consequences. This is what happens to real people. Right.
The story of what happens is oftentimes completely the opposite of what people are conceiving. You know, they know, well, what's going on there. So
right.
Well, it's been a real pleasure to have you on the podcast here in San Diego, California. When can we come out to Hawaii?
Yeah, you got any openings?